Good morning, everyone, and welcome to the Carly Copyright Q&A webinar. Our presenter today is Sarah Benson. Sarah is an assistant professor and copyright librarian at the University of Illinois at Urbana-Champaign Library. She has a JD, a Master's of Law, and a Master's of Library and Information Science. She also has a podcast called Copyright Chat, and you can find it in iTunes or at the following website, library.illinois.edu/SCP. And without further ado, I will turn this over to Sarah for her presentation.
Well, thank you for that introduction, and thanks for having me here today. Thanks to everybody who is participating, and I will try my best to monitor the chat if you have questions. I did get some questions in advance. I'll do my best to answer those, and let me know if you have trouble hearing or anything like that. I did want to plug that my unit at the library here is co-hosting with Carly the Scholarly Communications Roadshow that is happening on Friday, May 4th. If you haven't heard about it, check it out. It's from 9 to 4:30 at the I Hotel in Urbana. It's going to be a free event. It's going to be wonderful. They have two scholars coming to present about institutional repositories, outreach and programming, and open educational resources. So if any of those topics are of interest to you, both of the folks presenting are copyright librarians, so I know that they're going to mix copyright into the mix as well. You can find information at carly.illinois.edu/acrl-communication-roadshow. And if you didn't get all that, I'm sure we can type it for you as well. So welcome. You all have lots of superpowers related to copyright, and that's what I'm going to be talking to you about today. All of you are writers. Anybody in this room, by show of hands, I think you guys know how to show hands, who owns a copyright? Show me your hands. I see a couple hands. All right, so a few people own copyright. All right, that's actually a bit of a trick question because everybody owns a copyright. You probably own multiple copyrights. So what is copyright? It's a bundle of rights provided to authors with an end date. So let's get into why we all kind of own copyrights. It's really easy to own a copyright. You have to create something that is minimally creative. That bar is pretty low. Write it down or record it, which is the fixation requirement. And after 1989, that's all. That's all you have to do. Then you own a copyright. So the length is generally the life of the author plus 70 years. However, it could be longer if it's a work made for hire, or shorter, depending on how long someone lives. But work made for hire would be something you created for your employer in the course or scope of your employment, and then it would be a set 95 years from date of publication, or 120 years from date of creation, whichever is longer. So notice that you didn't have to do certain things such as put on a copyright notice. You didn't have to register the copyright with the Copyright Office. You didn't have to renew the copyright with the Copyright Office. So how many of you own a copyright on something? How many of you have written a paper recently, or given a presentation recently that you wrote stuff down for, or drew a picture, you sung a song that was your own creation for your child at night? I mean, all of these things, right? If you wrote it down, you wrote a poem, you wrote a blog post, you wrote a long descriptive thing on Facebook. We all own these copyrights, and we own lots of them. So hopefully I've convinced you that you all own copyrights at this point. But if not, please do ask any questions. Let's keep going and talk about what you own it in. So what rights might you have? Well, this is what we call the so-called bundle of rights. You have the right to reproduce or make copies. You have the right to distribute the work or sell it or put it on the web. You have the right to create derivatives. So my favorite example of derivative work is fan fiction. Anybody into fan fiction here? Anybody write fan fiction? Read fan fiction? There's got to be some librarians who like fan fiction, right? Um, well, technically, fan fiction is a violation, or you need the permission of the owner of the work. So if someone's writing, Harry Potter fan fiction, technically they'd need the creators or the owner of the copyright, maybe the publisher's permission. But we know that it wouldn't look very good if Harry Potter's publisher is constantly suing people for fan fiction, so they usually let it slide, right? But technically, that would be a derivative work based on the original. There's also the right to perform the work. So you'd see like a play that's being performed or music that's being performed publicly or public display. So like a display in the library, that would be a public display, or a display at a museum. So we do a lot of these things in the library, right? We reproduce, we distribute works, we perform and publicly display works, a lot of these things. So bear that in mind. All right, some things, some ground rules about what copyright protects and what it doesn't protect. So it protects all the things that we consider creative. All right, so writing, choreography, music, visual art, recordings of music after 1972, film, architectural works. There are limits though, so copyright is one of the intellectual property rights that we have, but there are others, right? There's patent for useful articles, so copyright doesn't protect useful articles and mechanisms and things like that. And also useful articles such as like the design of a chair, that's considered a utilitarian function, a useful function. It doesn't protect that, but it might protect the creative parts of the chair, like if you have etched engravings on the arms of the chair. That would be the creative part. It doesn't protect ideas. So if you don't write it down, it's just in your head. Copyright doesn't protect that. It doesn't protect facts. Nobody can own the date of World War II, for instance. We all own that. Doesn't protect names, titles, slogans, or short phrases. That might be trademark protected, but it's not copyright protected. So this Nike swoosh or Nike, it doesn't protect data, but there is kind of a side note because so data is considered facts, but if you have some creativity in the arrangement of the data, then you might have a small amount of copyright overlaying those facts. All right. Any questions so far? We're all good. We're all good at this point, I think. Hopefully. If you do have questions as we go, feel free to, as I said, post them in the chat. I can see the chat. I see that the ACRL Roadshow link is in there. That's great. All right. So this is the very basic stuff. So who owns the copyright? The author owns the copyright, right? The person or the people who created the work. And I did give the caveat of a work made for hire because the employer would own that. Interestingly, at the University of Illinois, everything that I do for scholarship and teaching, like creating this PowerPoint, for instance, would be owned by the Board of Trustees of the University of Illinois because I'm doing it as an employee. I get paid monthly. They take out Social Security. I'm clearly an employee. And I also do it within the scope of my employment. So I'm doing this because I'm employed as a copyright librarian. However, by the statutes of the university, the Board of Trustees does not want to own my copyrights. So they gift it back to me and I own it myself. And that's great. So I can enter into agreements with journals to publish my scholarly work. I can put a Creative Commons license on my work. If you notice, my slideshow has a Creative Commons license on it. We'll talk a little bit more about that later. So I just wanted y'all to understand that sometimes, the university doesn't want to own your work and they might gift it back to you. We would check your governing documents. In the University of Illinois, it's the statutes. Now, if you are joint authors, the default rule by the law is that each owner has an equal, undivided interest in the copyright. Now, this is interesting for folks who co-author or multiple author works, right? We do it all the time. I'm on a work with 3 authors right now, and we didn't sit down and like enter into an agreement, so the default rule applies. But when the the default rule applies, if someone calls me, and let's say I'm the 5th author on the work, which usually means like I didn't do as much work, right? Somebody calls me and says, well, can I like your work? Can I put it on my website? And I say, sure. That's all they need, because I have an equal, undivided interest in the whole work. So in other words, we all own the work. So they can ask any of us. Now, ethically, should they do that? I mean, we all know the 5th author is not the most important author. They probably shouldn't. But we know that legally they can, and I have the right to do that. So it's not a bad idea for folks who care about, how things are divvied up to actually write down and enter into some sort of agreement about who can make those kinds of decisions, because default rules, we all own it, and then any proceeds that we get, if we made any money off of the work, would have to be divided equally among all of us. So the 5th author, the 100th author would get an equal share in the work, which is like crazy, right? Because again, we know the 10th author did like no work almost, right? They just put their name on there as a courtesy or something. So anyway, I just wanted to mention that, because a lot of people don't know that that's the default rule, and they're like shocked when they find out. All right. So what work is in the public domain? We hear people throwing around the word public domain all the time, right? Well, that means work that no longer has copyright protection. In other words, copyright protection has expired. And public domain means we all own the work, right? It's owned by the public at that point. So we can do whatever we want with it. If I find an image in a book published before 1923, let's say a 1920 book, and I want to put it on a t-shirt and then sell it, I could do that, because again, nobody owns that work. So the current rule of thumb here is work, actually I said work published in the United States, but you really, international work here qualifies too, because, and I'll get into this in a second, because copyright law is territorial, and wherever you are, that law applies. We are all in the United States, so United States law applies. So work published before 1923 is in the public domain. Why is that? Because before 1978, copyright law was not the author's life plus 70 years. Okay? The rule was it was 95 years after it was published. So anyone who's good at math could say 1922 plus 95 equals 2017. So on January 1st of 2017, everything 1922 and before was in the public domain. Well, if you are good at math, you also know that that's a moving target. So we're about to celebrate a whole nother group of things falling into the public domain, which would be the 1923 works on January 1st of 2019. All right, so this is a moving target, and more things fall into the public domain every year as that 95 years expires. Now, this brings me to another point about U.S. copyright law. First of all, it's territorial. This is all copyright law. It's territorial. It depends on where you are physically in the world, right? So if I write something in France, France copyright law applies. But if I write something in the U.S., U.S. copyright law applies. Interesting, right? This is for all you people who may take a sabbatical. Think about that. You're going to take a sabbatical. You're going to go somewhere around the world. Interesting copyright conundrums there. So anyhow, but while you're here in the United States law applies. And the other thing I wanted to point out is, and you probably have guessed this already, copyright law is not retroactive. What does that mean? It means that copyright law from today applies today, but copyright law from 1923 still applies to works published in 1923. Does that make sense? So that's why we have that 95 years that it expires, and we get things to fall into the public domain. Anne Marie says, do you really think Disney will allow 1923 to become public domain? Yes, I do, because things have already been kind of falling into public domain. You're right. 1923, January 1st, it's a big year. They might lobby to change that provision, but they got a lot of what they wanted with this life plus 70. It used to be 95. It used to be, and before that it was like 56. So they've gotten a lot of what they want. So I'm pretty optimistic that this January 1st, 2019 thing is going to happen. I'm already planning exhibits. I'm really planning for it. I'm counting on it. All right, so another thing that I wanted to mention, though, is that works published in the United States between 1923, I think it's actually 1978, may be in the public domain for failure to comply with copyright formalities. So what do I mean by copyright formalities? I don't mean like works that are wearing a tuxedo or like a fancy party dress. I know I always make stupid jokes. My students, when I was teaching, used to say, Professor Benson, you're really not very funny. And I'm like, I know, but I still try. I just keep trying. Because, you know, I will never be a stand-up comedian, but I keep trying. So if you appreciate my jokes, yay, they're really lame, I know. So, copyright formalities were, you know, works used to have the copyright symbol. And sometimes it had to be, depending on the particular year, in a very specific place. So maybe on the very first page of the work or somewhere where you could reasonably find it in the work. So a lot of times when folks are looking at works between 1923 and 78, I say, flip through it. If it was published, it had to have a copyright symbol. If you don't see a copyright symbol, it's in the public domain because they did not comply with that requirement. So it's pretty fun. That's what the HathiTrust Research Center is doing when they do their review of copyright, that they're looking for those copyright symbols or lack thereof. And then the other thing they had to do was, in certain times, they had to register the work to get the first round of protection, the 24 years, and then within that time frame, they had to renew the work to get an extra amount of time. So there are ways to kind of look that up. I'm not going to bore you with how to do it because it's like annoying and it takes a while, but I will tell you that there's a really great chart out there as a cheat sheet, and I use it a lot, by Peter Hurdle. It's called the Peter Hurdle Copyright Chart. I'm going to put it in the Peter Hurdle Copyright Chart. If you Google that, you will find it. It's awesome. He updates it every year, and he is a very smart man. He knows exactly what he's talking about, and I really highly recommend it. I use it as a cheat sheet a lot. There are other cheat sheets out there. The Copyright Genie is one of them. There are a couple of them. The Copyright Digital Slider is another favorite of mine. You kind of move the copyright slider on the right to the year, and it will tell you if they had to, you know, renew it or if they needed a copyright symbol and stuff like that. So there are ways to figure out if these works are actually protected or not. One cheat sheet way that I use, and I'm going to be honest here, is I go to the HathiTrust and I look and see if I can see the whole work. And if I can, that means I'm right. If I thought it was public domain, I'm probably right because the HathiTrust has been doing this review. And if it's still copyright protected, then it probably doesn't fall into the public domain. So that's a way to kind of check your work also. Oh yeah, thanks for putting in the copyright chart there. Okay, so any questions about this? This era is a little bit confusing. Someone also asked a really complicated, it seemed complicated, but I'm going to make it simple. A question about a work published in 1920 in Hong Kong, China. And they said, oh man, I wanted to digitize this work, but I couldn't figure it out because it's China. And I'm going to tell you right now, it doesn't matter that it was published in China. If it was pre-1923, you're good to go because you're applying US law to that work. Now, what about work between 1923 and 78, this weird era? That's where we get into problems because we have what's called the Copyright Restoration Act. And basically, we were really nice to folks and said, oh man, US works had to comply with these formalities, but you know, international folks, they didn't understand these formalities. So we're going to, you know, extend their copyright. So that's where you get into problems. If it's after 1923, it's in this weird wonky area that some things might have fallen into the public domain. We've kind of gifted back the works from other countries. and we have given them longer copyright, even if they would have fallen into the public domain. So there's a circular on that, Circular 38B at the U.S. Copyright Office. It explains the Copyright Restoration Act. It's actually in Section 104A of the Copyright Act. And, you know, it gets complicated fast, folks, so I'm not going to go into huge amounts of detail. But again, if you, I mean, I answer questions daily about anything copyright related, so you can always email me if you have one of these wonky international works, and we can try to figure it out, because there's other exceptions, like works in the last 20 years of their copyright term get gifted back to us. That was kind of a compromise that happened in the Disney era. Some of you have probably heard about some work going on there, trying to digitize works in the last 20 years of their copyright term. So there's a lot of ins and outs here, and I don't want to bog us down too much in details, but I did want to say that Chinese work from 1920 would have been fine. If it had been 1925, it would have been a little trickier, and there would have been more analysis. And yes, sometimes we do end up looking at the law of that foreign nation to get around this restoration. So to get around the restoration, again, I'm getting in the weeds, so you can feel free to tune me out, but to get around the restoration, if January 1st of 1996, it was within the public domain in its home country, then we can digitize it. So there's so many exceptions to the exceptions to the exceptions. This is why copyright law gets complicated fast. I'm not trying to bog you down in all this, but again, you know, if you have one of these weird wonky things, just know that copyright restoration applies here. You might have a wonkier issue, and I'm happy to talk to you about it. All right. I'm going to stop for a second and let you ask questions if you have any, or to say please stop talking about this. I am so mad right now. How do we feel about this? Do we feel did anybody want me to talk more about restoration, or is this something interesting to you? Jen, is that saying you want me to talk more about restoration, or you're ready? You're ready for me to move on? I see you raise your hand, so I'm not sure. Oh, you're typing. Okay. That was an accident. Okay. That's fine too. All right, so I think I'm going to move on, but again, we can come back to this if we need to, okay? I'm just trying not to make it overly complicated. All right. Why can libraries loan books at all? I was going to try to play this thing, but because of copyright, I can't play it. Oh, darn copyright. It's from the Colbert Report, and usually when I am live, I can just stream it and show everybody, but we couldn't figure out how to get it to work with the volume. So I'm just going to explain what happens, and you guys can watch it on your own. But he has this thing called Judge, Jury, and Executioner, if you've seen that clip. And he's talking about a famous U.S. Supreme Court case called Kirtsaeng. And in that case, this student, an enterprising student, went to Thailand, I believe, his home country, and he bought up U.S. Textbooks, okay, that were being sold much cheaper in Thailand. Why? They're sold cheaper in Thailand because people can't afford expensive textbooks. So what did he do? He shipped them, he had his family buy them up, ship them to him, and then he sold them in the US, and he made millions of dollars. This is when everyone goes, what? What? Are you serious? And Stephen Colbert was like, yeah. So anyway, millions of dollars, and of course the publisher got mad and sued him. And it went all the way to the Supreme Court, and the Supreme Court said he was totally allowed to do that. Why? Because of the right of first sale. The right of first sale means that once you have extinguished your sale by selling the item, you're done. So I can sell things in my garage, right? I can have a garage sale, and I can sell my collection of Harry Potter. Why can I do that? Because of the right to first sale. I don't have to ask the publisher. I don't have to give the publisher a commission, right, for doing that. This is why libraries can loan books too, because we buy them, right? We buy the books, and once we've bought them, we can lend them for free. All right? So that's one of our biggest superpowers, but that's a superpower of like America, right? Everyone in America can do that. We sell used CDs, we sell all sorts of things on eBay. This is how eBay exists. Like everyone said, like if the Supreme Court had decided differently, eBay would die, right? Amazon, the used textbook market, and all that. So I just wanted to bring that up because everyone, that's the very first principle that we can all use in our life. The other thing that I wanted to mention is we're actually very lucky in the United States because we don't have lending rights. One of the bundle of rights that authors own in foreign countries, some European countries and other areas, is this lending right where libraries actually have to pay for how many times users borrow their books. Isn't that insane? So they buy the book and then they have to pay to the authors for lending them. And guess what? They pay to some big corporation who is supposed to disperse the funds to the authors and basically just makes tons of money. A lot of times those funds are misused and they're not well tracked and all sorts of things. I mean, can you imagine tracking how many times Harry Potter was checked out from the library so that we can pay the publisher, royalties who might then pay the author? I mean, it's ridiculous. So luckily, we don't have public lending rights in the U.S. I'm very happy about that. We have a right to first sale, and that's it. Okay. So now, other things that we get to do besides just lending things, we get to make copies of things. All right. So Section 108 of the Copyright Act allows us to copy things for preservation and for reproduction for ILO. So we can lend things. Library Section 108A is for library preservation. All right, so the folks in preservation can make copies of things. If they can make one copy. If it's for no direct or indirect commercial advantage, and that's all I've got in there. But also that the library and archives for number 2 are open to the public, or available to researchers affiliated with the library or with the institution. So most of us are open to the public, so we qualify. And we also have to include a notice of copyright on the record that we reproduce. So we can make one copy for no general, sorry, let me take a step back. I've totally ruined this part of the presentation. One step back. This is for us to make like lending copies, okay? So we can make one copy, one of our employees can make a copy for a patron as long as it's made without any purpose of direct or indirect commercial advantage. So this is when someone comes up to you and says, can you make a copy of this work for me, right? We can, and these are the overarching principles that apply to all of the rest of these sections. So this is the general requirements, and we'll get into the specifics in a minute. So can we make copies for people? Yes, but we have to not do it for commercial advantage. So we can't do it for, someone who's making it for a movie or something. We have to be a qualifying library, and it has to have a copyright notice. Those are the general qualifications. So 108A, we view this as you can't make use of any of the other Section 108 powers unless you meet these general requirements. All right? I'm going to assume, and that's why I didn't put all of this in here. I'm going to assume all of us work at a library that fits this qualification, that it's open to the public or available to researchers who don't just work with us, who want to come in, and that, okay, so that's the main requirement. All right. So 108A equals main requirement to qualify an institution for Section 108 superpowers. Okay. So I didn't put a lot of that in there because I'm assuming we all qualify for that. All right. So now we're getting into preservation. I'm sorry. I got you guys confused because sometimes I get confused. Sorry. All right, so we understand 108A is just the qualifying provision. Then 108B, this is what governs preservation. So the folks who are working in preservation can make up to 3 copies of an unpublished work. Underline that, because this is the line drawn. They can make more copies here of an unpublished work. Why? Because if it's not published, there probably aren't very many copies of it. It might be a letter, a handwritten letter, right? It might be, a document that is deteriorating, or, it might be the only copy in the world of it. And they can make up to 3 copies solely for purposes of preservation or to deposit in another archive or library, as long as they meet these requirements, right? The copy is currently in the collections of the library, and the copy that's reproduced, if you make a digital format, so like you make a PDF or someone can see it on a computer, you cannot make that available in a format outside the premises of the library archive. So you're supposed to make a physical copy and keep that copy or hand out that copy. You're not supposed to email a copy. You're not supposed to, you can put it on the computer, but they'd have to come in physically and look at that on the computer. If they wanted a copy, they'd have to get a physical copy. Does that make sense? So this is very limiting, and a lot of folks don't like it because this whole digital format thing, not distributed outside of the premises, what does that mean, right? Today in modern libraries, here, for instance, at U of I, you can log into the library from your home using Shibboleth, right? Is that outside the premises of the library? Technically, it's outside the physical premises, and this is why Section 108 we've been advocating, some people have been advocating for change over time, because it was enacted a long time ago, and there's been a lot of change in libraries since then. But right now, this is what we have. This is the law. And so we have to interpret what that means. What does it mean outside of the library? Does it mean the physical premises? Does it mean the digital premises? We don't know exactly, because there's no case law interpreting it. Why? That's a good thing. Libraries are not getting sued. So we exercise our Section 108 powers, and we don't get sued, and we're happy about that. So most people, think this is a good thing. Let's not mess with it. All right. So this boils down to a fairly broad right to make reproductions of unpublished work for preservation, but the digital copy is not supposed to be sent via email, for instance. And people wanting to see the digital copy are supposed to come to the library archive. All right. So that's the bottom line of Section 108B. All right, let's look at Section 108C. This is for published works, okay? So the last one was unpublished. So if you want to you can make up to 3 copies of a published work, but there's more restrictions. So there's less restrictions on the unpublished work. You can just do it for an unpublished work because you're trying to make backup copies. You only have 1 copy in the world. Here, for a published work, it has to be a replacement copy of a work that is damaged, deteriorating, lost, or stolen, or if the existing format in which the work is stored has become obsolete. And you have to do these other things. You have to look and make a reasonable effort to determine that an unused replacement cannot be obtained at a fair price, and that any copy that is reproduced in digital format cannot be made outside of the premises of the library. Again, same thing. But see how this is so much more restrictive? And I think, again, it's because published copies are easier to come by. They want you to make a reasonable search to see if you can get a replacement copy by buying it. And also, you can't do it just for any work. It has to be damaged, deteriorating, lost, or stolen, or in an obsolete format. Okay? So what does an obsolete format mean? Well, the law says a format shall be considered obsolete if the machine or device necessary to render perceptible a work stored in that format is no longer manufactured or is no longer reasonably available in the commercial marketplace. I use as an example microfiche, and I know it makes librarians mad because they're like, this is not obsolete. It's obsolete for purposes of copyright because it's really expensive and really hard to get a whole new microfiche machine. It's really not, they're not really manufactured anymore, right? So a lot of folks are backing up their microfiche content and making copies of it, right? And keeping it because, as we looked, the work stored has become obsolete in that format. So you can then duplicate the work. Now, The interesting other reason Section 108 has become kind of ridiculously old-fashioned is the 3 copies, right? So when we duplicate work, we usually have like a PDF, and then we might have it on like a disk, and then we might have it, on the web, and we might have it in our, database. And so 3 copies means 3 copies total. And nowadays, that's pretty weird. Like, we usually have more than 3 copies. So I don't want you guys to feel like, oh no, we violate the law every day. I mean, all of these Section 108 powers are, in addition to them, we have fair use. And so I don't want you guys to feel like, oh, this is the law. The law has become a little obsolete and out of date. And unfortunately, we're kind of trying to interpret that along with fair use. All right. So are the following technologies obsolete pursuant to 108C? VHS tapes. Is that obsolete, guys? Maybe just post in the chat. Who thinks that VHS tapes are obsolete? Well, we've got a disagreement going on here. How many of you have tried to buy a VHS recorder on like eBay or Amazon? Can you do it? Can you buy a VHS recorder? Yeah, you can, and it's not that expensive. So VHS tapes are not really considered obsolete, all right? So we're not really allowed to just back up all our VHS tapes, okay? What about floppy disks? Yeah, floppy disks, oh my gosh, we have to back that stuff up, right? Yeah, super obsolete. Floppy disks, like we don't have computers that even take floppy disks. You cannot get floppy disk computers anymore. So yeah, we have to convert that stuff, and we're allowed to. All right. What about undeveloped photograph film? What do we think about photograph film? Yeah, we can still get that developed, right? You can even go to like, what? You can go to your like Walgreens or somewhere and get it done, right? I don't know. It's not that hard. And then microfiche, that was the example that I used. And I don't know, I did this presentation for a bunch of librarians and they got really mad. They said microfiche isn't obsolete. I said, I'm talking about copyright law obsolete. I'm not talking about obsolete like, I know libraries still use microfiche because it takes a lot of time and effort and money to back up all that stuff. But like the Library of Congress right now is backing up a ton of microfiche. Are they allowed to? Yes. Right? They are. Okay. All right. So, okay. So I also wanted to note 108C, note the restriction on viewing the digital copy on the premises. There are many debates about what constitutes a fair price for an unused copy, but use your good judgment, right? People look for like licensing, and they look at the like general databases where you would buy your copies of books, right? And you look through them and you see how much does it cost to get a replacement copy. And if it's ridiculous, it's like trying to buy this one little book and it's going to cost $2,000. That's obviously not a reasonable price, okay? So you have to use your good judgment. There's no like exact rules there about where you have to look and all that. All right, interlibrary loan. This is one of our favorite librarian superpowers. And I'll tell you that in South America and Latin America, most countries do not have interlibrary loan. Can you believe this? It's not part of their law. That's why open access is such a big deal in South America, because without it, people can't really get access to a lot of materials. So it says that the rights of reproduction and distribution apply to a copy made from the collection of a library archive where the user makes his or her request from that library or another library archives of no more than one article or other contribution or a small part of the work if it's for private study, scholarship, or research, and you include, warnings of copyright. Okay. So this is if people want a small part or one article. We do this every day, don't we? How many of you guys work in ILL? By show of hands. Yeah, some of you. Maybe I don't see anybody. Oh, yeah, there we go. Okay. So this is what allows you to do this, right? This is a librarian superpower. This is making a copy of something. This is not our right of for sale. right? Because we're not just using, now the right of first sale is different, because the right of first sale is I have a physical copy of a book. I can lend that book, of course, but we're making photocopies of the book. We're making photocopies of the article, right? We're not just lending like the original thing. Sometimes we are, but when we're making a copy, this is our superpower that we have that, again, in South America, some libraries don't have. And it's really important to recognize that this is an awesome thing. We don't ever want to lose this. And again, we're not getting sued over this. There are almost no case law interpretations of it, so we're not getting sued, which is great. All right. So note that only a small part or portion of a book may be copied. This is for private study, scholarship, or research, not for commercial use, folks. Like, someone shouldn't come to you and be like, I'm putting this in a movie. No. Note that the request should come through a user or another library archives. There are some restrictions. Cannot be made for musical works, pictorial, graphic, or sculptural works, or motion pictures or AV works. So you're not making copies of a movie or something. This applies to both published and unpublished works. Okay, so that's our general ILL. And then Section 108E is if you're trying to make a copy of the entire work for ILL or a substantial part of it. So you first have to do a reasonable investigation that a copy of the copyrighted work cannot be obtained at a fair price, because that patron is supposed to buy that work. All right, you can't just make a photocopy of like an entire book and send it to them, an ILL, right? They're supposed to they're maybe supposed to buy that, or that library is supposed to buy it. And then if the copy of the phonorecord becomes the property of the user, we shouldn't know that they're going to use it for anything other than private study, scholarship, or research. So that's why ILL forms usually say, what is this for? Like, tell us, is it private study, scholarship, or research? And you want them to click one of those things and not like, I'm selling this, and you also have that warning of copyright. So it's a lot harder to as you see, to lend an entire work. The entire work may only be provided if, after reasonable investigation, it appears that a copy of the work cannot be obtained at a fair price. Published and unpublished works, but it doesn't apply to musical works, pictorial, graphic, or sculptural works, or motion pictures. Okay. So in Section 108, there were some questions about, this was last time I did this, there were some questions about the following. What does it mean to make a digital copy, and does photocopying count? A single photocopy is an analog copy. A digital scan means a scan of the document or sending the photocopy via email. That's digital. So once you put it on a PDF, it's digital. Okay? So photocopying is an analog. That's okay. What does physical premises mean? Again, this is where 108 is getting outdated. Today we think of the library as the entire system. But at the time of enactment, they meant the physical building. They meant you physically have to come in here. And some of our stuff has been locked down to the point where we have like barriers from the IP address even. Like you can only log in like in this one library, in this one room to view it on physical premises. Okay, hypotheticals, let's discuss. Because, I don't think we can understand Section 108 until we like really try to apply it. So you can answer in the chat, all right? Can the library make a digital copy of a published article about the demotion of Pluto as a planet from its collections for a user for the purposes of private study, scholarship, or research? Yes or no? What do you guys think? So are we talking about, we're talking about ILL basically, right? It says the rights of reproduction to a copy made from a collection. They make one article. This is one article, right? The copy becomes the property of the user, and they display the order form a warning of copyright. There's nothing saying it can't be a digital copy here. So those of you who are saying it's okay are right, all right? So there's no requirement that you can't make a digital copy. We do this all the time. How many of you send PDFs to other libraries digitally, right, of works through ILL? How many of you guys do this for small, one article or a little small portion of a work? You guys do this? I think you do. I hope you do. Okay. So yeah, so you can, but can you put it on the web page? No. Yeah, no, you can't. Emily's right. You cannot put it on the web page because then it's not for private research and all that, right? You'd have to do a fair use analysis there and have some other justification. Okay. Another example. The library wishes to make a copy of an unpublished archival document. It is the only one the library has. Can it? Can the library make that copy for preservation purposes? It's unpublished. Yes, right? Yeah. We said, of course they can, because that's what it's all about, right? You can make it automatically. Remember, for unpublished materials, automatically, it's less likely to be able to do it for published materials. What can they do with the photocopy? Can they let people view it in the library? You come into the library, can you look at it? Sure you can. Yeah. We said on the physical premises you can. Can you let people make a photocopy of it in the library? They come in, they look at it, can they make a photocopy of it? Yeah, I like Jennifer. That's exactly right. Yes, if for personal use. They can't go and sell it, right? But they can do it for research and things like that. That's why our archives are so awesome and useful to people. If they come in, they look at stuff, they can make a copy of it. Can we scan it and make it available on the library website? Yeah, people are saying no. And I'll say probably not. And again, this is where fair use comes in and kind of picks up the slack here, right? Yeah, so depending. Yeah, Anne-Marie's more like maybe. That's right. Because maybe a thumbnail image for indexing would be okay, but not like a high quality resolution image. So it really depends. All right. But remember, Section 108D and E, the interlibrary loan, don't mention the digital physical premises issue, right? So you always can send those electronic copies, but it gets stickier if it's a full work, right? If it's a full work, it's different than a small portion, and you always have fair use. So Section 108F4 says, nothing in this section in any way affects the right of fair use as provided by Section 107. Okay, so we always have the right to fair use. We even say the right to fair use. Yeah, nothing in the section in any way affects the right to fair use. And fair use operates in conjunction with Section 108. So a lot of times in our archives, we have Bill Maher, who's the head of our archives. He is amazingly familiar with copyright. So any of you all who work in archives and have questions about what we do or what can be done, I encourage you to reach out to Bill if you have questions. I mean, in addition to myself, because he knows a lot about copyright as well. And he exercises his fair use rights pretty liberally, and I think that's good. I think we want people to not be afraid of where Section 108 ends and to operate in conjunction with fair use. All right, so I'm going to stop before I think I move. Oh, wait. Oh, here's the part. Wait, before I stop, I'm going to say Section 108H. You guys have heard of the work of the Internet Archive, digitizing works within the last 20 years of copyright, and I mentioned it earlier. This is where it comes from. It says, if a published work is in the last 20 years of its copyright term and is not reasonably commercially available, i.e. out of print, a library archive may reproduce, distribute, or display or perform in facsimile or digital form a copy of the work. That's why folks have been putting stuff on, online. And we, in my library, have extended this to foreign works too, because there's nothing limiting it. And so if we have a foreign work that would have been restored under between 1923 and 78 to 95 years of protection and would still be in copyright, if it's in the last 20 years, say from 75 to 95 years after publication, we have gone ahead and digitized it. We've made that call. So, so this is something you might have heard about, is an ongoing project going on. Oh, okay, and Section 108 reform. Don't you love how I get surprised by my own slides? This is surprise! Section 108 reform has been going on since 2004, people. The U.S. Copyright Office released a discussion document recently in September, and it proposed a new model statute for Section 108. There's no indication this will happen anytime soon. I really hope it doesn't, because really, honestly, Section 108, outdated as it is working just fine, and we're not getting sued. And I do not want conservative folks in Congress to get their hands on library provisions, because I just don't think anything good will come of that. So I'm very much not happy if Section 108 gets meddled with. But anyway, it's been going on for a long time. Nothing's happened yet, so I'm hoping nothing will happen. Okay, at this point, Section 108, I'm gonna open it up to questions if you have any. I'm sorry I got confused about Section 108A. It's really the overarching provision that says, like, you can't use any of Section 108 unless you meet these requirements. And you're basically like a public library, or you could be a corporate library, but you allow anyone to do research there. And then you get the benefit of Section 108. So sorry I confuse myself sometimes. The law is not written really well, which is part of the reason it's confusing. And that's the other reason people want Section 108 reform. But again, I say, you know, we are using these superpowers. We're not getting sued. Let's just keep on keeping on. Anne Marie, you say, what's in the wind? What do you mean by that? What's in the wind? What's in the reform? So the reform, one of the things that they're trying to do is kind of get rid of this digital physical divide issue, where like libraries are not just like a place where you come in, right? There's like the electronic walls of the library where you can log in from off-site. So they're trying to deal with that. They're trying to add museums. So Section 108, by its terms, does not incorporate museums, but a lot of museums rely on it anyway, and they've been doing so successfully anyhow. But it was one of the reforms was trying to incorporate museums. Oh, so ILL forms, adhere to copyright policies. I mean, it's not a bad idea on an ILL form to like say, like, give them a reason to tell you the purpose, but just to kind of make sure that you know it's for research purposes, and just make sure it's not for commercial purposes. We actually, after I did a Section 108 workshop in our library, some folks in the digital section changed our ILL form a little bit too, just to like make sure that we allowed for personal use too. So I think it only said like research or scholarship, and I said no, personal use is okay, and that's good to note. It's mostly commercial use that they're trying to avoid. I think our form is probably on our website. You could look at it if you want a model form to use. Other questions? Any other questions? All right. Oh, Judith. Would personal study rather than use be better? Sure. I mean, it's always really, really good. Yeah, it says private study, whatever that means, right? I mean, using the actual word of the statute is a great idea, right? Because then you're even more like specifically adhering to the terms. Right. So I would just, what we do on our form is we just use the words from the statute. So it says private study, scholarship, or research. Those are the purposes that are permitted by the law. And so that would be what you would want them to be asserting that they're doing. Yeah. Some folks were wondering about liability. This might be a good time to address those questions. So some people are saying like, I worry about when people come into the library and they use copy machines and they're like doing something that's wrong. Like what's the liability of the library? And there are also provisions in the Copyright Act that I didn't cover today, but there are some about the private use. Those are section 108G. And as long as you have a notice on your copy machine that says that, the people can't use it for any other use, for illegal uses, and they're things available in the library are copyrighted and all that, then and you're not monitoring the use of the copy machine, so you don't have like people standing over it, and as long as the patrons can make their own copies, then the liability is on the patron, not on the library. As long as you comply with the legal mandate of letting people know with a copyright notice what what is permitted and not permitted, then they have to make their own judgment at that point. So, and again, there's some standardized language I'd be happy to send out to people. If anybody wants it, you can email me. There's a pretty good book out there that has some standard language in it. But most of you probably already have it on your copy machines, but that's your obligation, is just put it out there, let people know. That's why we have to put the copyright notice page on ILL stuff. Because again, it's not our fault as librarians if people violate the copyright after we have done our job and followed our laws. And if we put the copyright notice on there and then they choose to violate it, that's not our fault. Okay. So those are good questions. But again, most of the time it's not the fault of the library. We're pretty insulated, which is good. Okay. Well, let's get into some really fun stuff about like general principles. And this is what I use like when I'm talking to teachers who want to do like e-reserves. I know some of you had questions about e-reserves too, so we're going to talk about that. So we talked about, public domain works. It says in your thesis, this is really for any kind of work. Anyone who's doing a research, when can they use other people's work in their work? They can use public domain works, which I'm going to brush over pretty quick because we already talked about that. Creative Commons licensed work, anything that's involved in a copyright exception. Fair use, which is really broad, and we're going to spend some time talking about that. And finally, they can ask for and receive permission from the copyright owner. I literally do my copyright analyses in this order because the last thing I want to do is ask for and receive permission. Why? Well, it might take a long time to find the copyright owner. So it's usually the publisher, but what if the publisher went out of print? Now who owns it? Did it revert back to the original author? Did it get bought up by another publisher? Also, they might ask for money, and a lot of times I don't have $500 sitting in my pocket. So I go through these things in this order and try to find ways to legally use work without paying fees if I can. I mean, I'm not saying like, don't ask for permission when you actually have to, like you definitely should. We already talked about this, but also works produced by the United States government in the course of their duties, like the U.S. Copyright Act itself is in the public domain. You can find it online. We've already talked about public domain, so I'm going to skip that a little bit. All right, Creative Commons licensed work. So this is work that the author has designated as usable by other people within certain limits. And it's like giving a license or a contract to like everyone and saying, this is how you can use my work, and you don't have to ask me for permission if you abide by the license. So there are different types of licenses. CC0 would be the broadest. That would be if someone wants to designate something as part of the public domain. If you use CC0, it means you don't have to ask permission, you don't have to cite me, you can do whatever you want with the work, you can even sell it. That's pretty rare, but it happens. CC BY would be more common. It's when someone wants attribution, like academic style attribution. You cite their name and where you got it from and the date. And then the tricky thing about the CC BY is that someone could commercialize the work. without asking your permission and without giving you any payment or anything. So for instance, I just published an article and it's licensed CC BY, and if a publisher later wants to put it in a book, they can, and they can sell it, and I won't get any proceeds. I mean, I will be cited, but that's the trick about CC BY. It's pretty broad. If you use CC BY NC, NC means non-commercial, so it could be used for educational purposes without asking permission. ND means no derivatives. If you don't want anyone to change the work in a significant way, you would put ND on it. Share alike is by far the most misunderstood one, but share alike means that if someone creates a derivative work from your work, which means they change it substantially, then they're supposed to use that same license that you put on your work on their work. So if you want, like, let's say I put share alike on this, I put CC BY NCSA. So actually that's, I think, how I licensed this one. That's how I licensed this particular PowerPoint. I want other people to be able to use it. I want it to be used in an educational setting, not for commercial profit. And if someone changes it in a significant way, I want them to also use it in a non-commercial way. So they'd have to use that same license. They'd have to put CC BY NCSA. Now, if they just take one picture from my slides and use it, they wouldn't have to put CC BY NCSA on their thing. They would have to cite my slide correctly, but that's not really a derivative work. They're just taking one photograph. They're not really changing much about my presentation. So that's the thing about share alike. You only have to use the share alike for derivative works that you make from the old presentation. That's where people get confused. Share alike is mostly misunderstood. But anyway, that's what it means. Any questions about Creative Commons license? You guys have probably seen some of this stuff. Maybe you've used it. I like to put it on my slides. You can go to like slideshare.org and find slides there. More and more open access journals are using it. You can search for things at creativecommons.org that have the license if you're trying to make presentations. It's kind of a great thing for like conference presentations if you want to use slides and different photographs and things. Oh, so Andrea says, if you use it, do you put it on your first slide only? That's what I do, because that's usually where the copyright notice is. The copyright notice is usually on the first page of the work. I mean, it's not going to hurt if you put it on the whole thing, but like, you know, usually copyright has to be displayed prominently where someone would expect it, which would be at the bottom of the first page. So that's what I do. But certainly you could put it on every single slide if you really just want people to be like really, really aware. One more important caveat to know about Creative Commons license: if you use it and put it on your work, it is irrevocable. So this is something that I caution researchers about. So I just had a research consult with someone, and they created something and they wanted to put a CC license on it, and I said, well, think about it before you do, because it's irrevocable. You can never take it back once you put it on, because people rely on that. And I said, you know, if you want to publish your work one day and the journal is not open access, they might have an issue with that. So you've got to think about, you know, other potential uses you might want to make of your work before you put a CC license on it. All right, so another exception that I talk a lot about, and libraries utilize this exception too, is the exception for face-to-face teaching. This exception permits the display or performance of audiovisual images and any other work for face-to-face classroom use, so long as the material is obtained from a legal source. So what does that mean? It means, it doesn't mean copies. It says for display or performance. So can my class stand up and perform Shakespeare because they're learning about it in English class? Sure.
Yes.
They're allowed to do that because of the face-to-face teaching exception. But you have to be in a classroom with registered students face-to-face. Doesn't apply to online teaching. You could use any version of something that you got from a lawful source. So let's say I have a video of Harry Potter that I bought at the grocery store and I want to show that in my class. I can. That's a legal source. I could borrow a copy of a DVD from the library and show it in my class. Again, that's a legal source. So these are all, that's why we have, so many DVDs and things that professors can use in their classes, and they can show the whole thing face to face. Again, not online. Now, there is an interesting caveat here. So what about Netflix? The Netflix problem. What if your professor wants to show a Netflix movie in class? Can they? What do you guys think? Put it in the chat. Can you show Netflix? Okay. Raina's like, I asked them. Okay, if you ask them, that's probably fine. All right, so yeah, Alice, you're right. So here's the issue. I have a Netflix account. Most of you probably do. When you sign up for Netflix, you click a license. That's an agreement. That's a contract between you and Netflix that says that you will use Netflix for personal use. Personal use means my own personal use, not showing it to a classroom of students. So technically, that even though I have a face-to-face teaching exception, the contract that I signed trumps that. Okay, so if I sign a contract, then I've given up some of my rights that I would have otherwise had. And so unfortunately, you're not really supposed to. Now, there are some people like Ava DuVernay with her movie The 13th. If you go to that website, she said she created like a license with Netflix that said you can use it for classroom use, for like panel discussions and other things like that. So it's pretty cool. Most of the time we're not supposed to. It would be really awesome if Netflix would allow universities to buy licenses for classroom use, but they won't. They won't come to the bargaining table. Copyright librarians have been trying for a while to get them to do it, but they apparently think that it's not worth it. So yeah, and I've heard other people have called Netflix and they've said fine. So I mean, I think that really depends on who you talk to at Netflix on a given day. But yeah, I mean, you have to call Netflix because otherwise, really not supposed to. All right, I just wanted to mention the interplay between licensing and general copyright principles. Okay, so let's get into fair use. I think you've all probably heard of this before, I hope, but I'm going to go through it pretty quick and just, talk about some nuances. So fair use is codified in Volume 17 of the United States Code, Section 107, and in the introduction to it, it says, the fair use of a copyrighted work for purposes such as criticism, comment, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. So we're done here, right? Everything universities do and academic libraries and libraries in general is for research and teaching and scholarship. Unfortunately, we're not done because it goes on. And this is also part of the statute. It says, in determining fair use, the factors to be considered shall include, which means must, and we must look at all four, the purpose and character of the use, including whether such use is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use upon the potential market for or value of the copyrighted work. And look at what they say, potential market. So it could be something they say, well, I didn't license this yet, but I'm going to, or I was going to. All right, let's look at these in turn, and I hope you appreciate copyright humor here. I abbreviated fair use FU. I hope I'm not offending anybody. So the first factor, the purpose and the character of the use. So is the purpose of the use commercial? It's less likely to be fair use. Is it educational? It's more likely to be fair use. This is like a spectrum. A lot of what we're doing falls on the educational spectrum, research spectrum, so that's probably good. The nature of the work, factor 2. Is it unpublished or highly creative? Unpublished works like my Aunt Maggie's diary, we want her to have the choice of when to publish that. So that's why it's less likely to be fair use. Highly creative work like Harry Potter, less likely. versus a factual or published work, more likely fair use, like historical work. The amount and substantiality used. So is the entire book or the heart of the book copied? Less likely to be fair use, or a small amount. If you take a small amount, it's more likely to be fair use. And the effect on the market for the original work. Does it replace the marketplace for the original work? That's less likely to be fair use versus it's substantially different than the original work. Now, I also want to mention here that fair use is an affirmative defense in the courts, which means that you can be sued for copyright infringement and have to defend for fair use. So unfortunately, there's no such thing as no risk involved with asserting fair use. There's always some amount of risk. That's why I encourage people to do a risk assessment. How risky is this when you make a fair use determination? But I also want to let you know that for a good faith fair use determination, if it's made by a library employee, we're shielded from liability for statutory damages, which are a lot of money, and they can only get a small amount of damages. So they're unlikely to sue a librarian for asserting fair use. So we have a superpower for fair use too, which is awesome. I don't mean that you should go around giving legal advice to your patrons, okay? Even as a copyright librarian, I'm not allowed to give legal advice, even though I have the bar in 2 states. I'm not employed as an attorney. I'm employed as a librarian. But what I can do is give folks information about fair use and send them, tell them what I'm telling you right now, send them to checklists, help them understand the checklist, all that, and let them make their own determination. But where do you all use fair use in your daily work? Well, if you create an online LibGuide, how many people do that? You might be using images. You might be using book cover images. You might be using other people's work in it, right? So we probably do that. If you're creating something for the web page on the library, you might be using fair use. If you are creating bookmarks for your library, I get questions about bookmarks or campaign materials where they're trying to send out things to get donors. You might be doing a presentation. Oh, a library exhibit. Fair use comes into play a lot in a library exhibit. Okay, so there are a lot of instances where you need to make individualized determinations of fair use in your daily work. Oh, lending in the archives and things like that, right? Fair use comes into play there too. Okay, so let's talk about this really tricky factor 1+, transformative use. I call it factor 1+ because it actually emanated from the first factor, purpose and character of the use. It doesn't matter what you call it. Some people call it factor 5, whatever you call it, it's a thing. It was developed by the Supreme Court in 1994. It's pretty awesome. And the Supreme Court said a transformative use is one that alters the original work with new expression, meaning, or message. What does that mean? It means you're kind of changing the work. My colleague Kevin Smith says, in order to determine if something's transformative, we look at 1, does the use transform the material by using it for a different purpose? And 2, was the amount taken appropriate to the new purpose? This is how you kind of are looking at all of the 4 factors with a gloss towards transformative, because the amount taken is that whole, did you take the whole thing? And you might have taken the whole thing, but is it appropriate for that transformative use? And if you're using it for a different purpose, chances are you're changing the marketplace value, right? No one's going to use your work as opposed to buying the original work, right? So it's a gloss over all 4 of the factors. And the more transformative the work, the more likely courts have been to find it to be a fair use, even if it's commercial. Because again, it could be commercial, but it's not aimed at the same audience. People aren't going to buy your work instead of the other work. Let's look at some examples. So the original fair use case was from Pretty Woman, the song Pretty Woman. And the Supreme Court in that case was analyzing 2 Live Crew's version of the song. 2 Live Crew took Pretty Woman and made a really bawdy, rap version of the song. It's really awful. And it was called Big Hairy Woman Walking Down the Street, and instead of Pretty Woman. But they took a lot of the lyrics of Pretty Woman. In fact, they took the whole first verse exactly as it was written. All right, and the Supreme Court in that case was really focused on the fact that it was a parody. I'm not going to make you explain the difference, but here was what they said about it. They said the heart of any parodist claim, to quote from existing material, is the use of some elements of the prior author's composition to create a new one that, at least in part, comments on the author's work. Why is it so important to allow fair use in parody? Because you have to use enough of the other person's work so that the person knows what you're making fun of, right? If I didn't recognize that they're making fun of Pretty Woman, the song, then the parody is lost. Satire, on the other hand, makes use of making fun of society, not the original work. Emily, I love that you asked about Weird Al. I love Weird Al, and a lot of what he does probably is transformative. It's probably not even a parody. It's more like a satire. But he pays licensing fees. He's famously known, yeah, Anne-Marie, you're right. He's famously known for paying licensing fees. Why? He has lots of money. He's just sharing the wealth. It's great. You know, and doing a cover of someone's song, really easy, really pretty cheap. So, so he could make a transformative argument, but he would also likely get sued, and he'd have to defend it. Yeah. All right. So, you know, they made this parody. The original lyrics were Pretty Woman walking down the street. New lyrics were Big Hairy Woman, need to shave that stuff. So why is this parody not a satire? You know, I don't go into this too much today because the reality is that this distinction has kind of been cut down. But when I will say, when you're making a parody, though, it's the heart of fair use because that's the one the Supreme Court addressed. All the cases since then have been lower courts, like in the intermediate level of appeal. The Supreme Court has not addressed this issue since 1994. I don't technically want them to because they're getting more conservative, but let's look at something here. So is this a parody? The Cat Not in the Hat, the O.J. Simpson murder trial. This was a cover to a book, and they said The Cat Not in the Hat, a parody by Dr. Seuss. Obviously, they took a lot of stuff from Dr. Seuss, and they're making fun of O.J. Simpson here, all right? So is this a parody of The Cat in the Hat? If it is, I want you to say A. If it isn't, say B. So think to yourself, is this about the Cat in the Hat? Is he making fun of the Cat in the Hat? If he is, it's A. If he isn't, it's B. Okay. So yeah, you guys are right. They're not making fun of the Cat in the Hat. The Cat in the Hat is about a cat who comes and plays with these kids and their parents are away and it's a rainy day, remember? They're making fun of O.J. Simpson. They're not making fun of the Cat in the Hat. So the court found that even though they said it was a parody, I love how their lawyer was like, if we say it's a parody, they're going to think it is. No. The judge said, nope, you were just lazy and you stole this and you should have gotten permission or paid. Okay? But since then, transformative use has gotten expanded. This was another case in the Second Circuit where Carew, who's a photographer, took these photographs in Jamaica for his book called Yes, Rasta. And then Prince, not the late great singer, a different Prince, took the photographs and changed them slightly. You know, you see how he gave this guitar and he blacked out the face a little bit and like muted the background. He sold this for thousands of dollars as fine art. In fact, Jay-Z and Beyonce have some of Prince's work. Not this particular piece, but they have some of his work. So he's made a lot of money on his like popular culture art. But he didn't ask for permission. He just took it. Is this a fair use? What do you guys think?
No. Whichever one says no.
Okay, so I appreciate your thoughts here because I actually agree. The judges in this case, they saw multiple examples. This was the kind of like least transformative one, but they said, we don't really know, and they remanded the case, and then it settled, so we'll never know. Yeah, someone said transformative question mark. I mean, we don't know, but I personally think it's pushing the boundaries of transformativeness a bit far. But some of his other things that did more remixing were found to be transformative. And this is what the court said. The court said Prince's work could be transformative even without commenting on Carew's work or on culture, and even without Prince's stated intention to do so. So some of the courts are like, we don't care about this satire versus parody thing. We just want them to comment on something else and transform the work somehow. Yeah, someone liked his art. Yeah, someone did. Someone paid a lot of money. They thought it was art. You know, this original photo, what was it for? It was for documenting historical nature of the work of people in the Rastafarian community. And this new thing was arguably art, right? So they're saying it's different, transformative. There's an argument to be made there. So a transformative work is one that alters the original one with new expression, meaning, or message, right? That is the key here. That's the key. And parody is the heart of it, but other things can be too. Here's another example. Any Grateful Dead fans out here? I like the Grateful Dead. Any show of hands, any Grateful Dead fans here? Yeah, we got at least one. Woo! Okay. So this man was also a Grateful Dead fan, and he wanted to create an anthology of the Grateful Dead and in this book and publish it. But he asked the author of the posters of the Grateful Dead, "Can I use your posters in my book?" And the author said no. So what did he do? He used them anyway, and he got sued, of course, because high risk situation when you ask someone to use it, they say no, and then you tell them I'm doing it anyway. So he got sued and he defended the lawsuit and he won because the court said, look, the purpose of the original posters was to advertise for concerts. The purpose of the posters embedded in the book was for historical context, right? And also he shrunk down the posters in size. It's not like he put the whole poster like full length size, you could pull it out, right? So I've looked on eBay and these posters still sell for like 60 bucks a pop. He's not hurting this guy at all, okay? Also, you're not going to put this guy's book on your wall instead of putting a poster on your wall. There's just no way, okay? So there's no harm, even though, guess what? This was a commercial use. He was selling the book. The book is actually pretty expensive. So the moral of the story is you can use your fair use rights even if you've asked for permission and someone told you no. Of course, your risk level goes way up. You don't have to ask, though. Another example. The HathiTrust Digital Library inputs entire digital copies of books and other materials. For copyrighted works, the general public cannot see the entire book, but can search for how many times a specific term is used in that work. So if you're looking for anaphylactic shock, you would search in the book and it would tell you it comes up 96 times, right? Is that a transformative use? A, yes. B, no. Yeah, you guys have probably heard of this case, right? Yeah, of course it is, right? Because what are you using it for? The original materials, the purpose is communication or reading, right? Your purpose of these term numbers is research, because if I find out that anaphylactic shock occurs 0 times in that book, then I know that that book is not useful to my research. If I find out that it comes up 1,000 times in that book, I know it's really, really important and I need to go get that book. And then what are you going to do? You're going to go and check out the book from the library, and of course libraries buy books, or you're going to go buy the book. So we're actually like giving free advertising in a way. But the moral of the story is even using the entire work and making multiple copies of the work can constitute a transformative fair use, right? Because those of us who work with the HathiTrust know that we're digitizing the work, and then the library has a copy, and then we're sending a copy to HathiTrust, and they're working with Google Books, so they have a copy. So there are multiple copies floating around of the entire book, and the courts have said that's okay. Same thing goes for Google Books, right? When you look up Google Books online, if it's copyrighted work, you see the snippet view. And the snippet view is when you just see a little part of what you're looking for, right? Not the term number, but more, like a sentence or two. And the court found that to be transformative as well, because they said, you know, when I'm looking for Einstein, this was the exact example they used. When I'm looking for Einstein, I need to know if it's Albert Einstein or Einstein the cat, you know, for a popular cartoon or something like that. So I need to see that snippet view. And then guess what I'm going to do? If I find it relevant, I'm going to go buy the book. It's free advertising. We're not hurting the market share at all. Jennifer asked, does the person making the transformative work have to give credit? No, you don't. So this is not a form of, this is copyright, not plagiarism, right? So like technically, like if you're working in an academic context, we're still going to give credit because of plagiarism issues. That's separate from copyright, right? So yeah, Prince, in his work, he doesn't give anyone credit. He just transforms the work, doesn't give any credit. Good question. Okay, here's another example. Is this transformative? Ferry took the photo on the left from the APA. It was a photograph for the news showing Obama sitting next to George Clooney at a National Press Club. I kind of wish I was either George Clooney or President Obama there because sitting next to either one of them would be all right by me. And then, so Ferry took that and he changed it into the Hope poster. So you see the direct comparison in the right-hand corner of the photograph and then the poster. So what say you guys? Is this a fair use? If you think it's fair use, say A. If you think it's not a fair use, say B. All right, so interesting. Like I did my own fair use analysis on this on my YouTube channel, which you guys are welcome to. If you search on YouTube for Sarah Benson, you'll see some. I made some really not exciting videos of me talking over PowerPoints about fair use and other things like that. But you're welcome to subscribe to my channel. It's kind of similar to what I'm doing today. Yeah, and I thought it was fair use, but not like obviously fair use. And interestingly, Ferry got sued. And we don't know what would have happened because he ended up settling. So we don't know what the court would have said. And he ended up saying that he was going to give all the proceeds from his poster to a place designated that the APA told him to give it to. And he said, in the future, I'm always going to ask for permission from the APA. So the Associated Press. So anyway, we don't really know. But interestingly, he did offer this poster to the Obama campaign. And the Obama campaign would not touch it with a 10-foot pole. And you know, Barack Obama used to teach constitutional law at the University of Chicago. So he knows a thing or two about law. And he was like, no. So interesting, all interesting. And we don't know the exact answer, but certainly, definitely could make a transformative argument there. All right. Some practice. So let's say a student comes into the library. And they're working on their graduate thesis, and they want to include the following things in their paper, and they haven't obtained permission. Can they and why? And like, again, you're not going to give them this type of legal advice, but we're just practicing to see like what, if we think it would be a fair use or not, or like assume that you're writing your thesis yourself, okay? So could you use a direct quotation of 50 words from a work by Judith Butler, published in 1990, with a strict copyright notice on the first page of the book? So it says, no one can copy this book, no matter how small, without express permission from the publisher. Can you do it? Is that a fair use? Yes or no? Yeah, you guys are right. This is clearly a fair use. Right, and no money being made. I mean, students do this all the time, right? This is a classic, just 4-part test analysis. It's not transformative. You're just copying it, blatantly, directly copying it. And yeah, students do it all the time. And I love talking to students about copyright when I ask this example, because I've had students look at me in a panicked state, saying like, "Oh my gosh, I was supposed to call the publisher." You know, it's like, no, you don't. You didn't have to call the publisher because you're taking a small amount. You're not transplanting the marketplace. No one's going to read your paper about Harry Potter with one block quote in it instead of like reading Harry Potter, right? It's just not that good. I'm sorry. But yeah, that's a classic example of fair use. So we've all been using our whole academic career. We just didn't know it was fair use. All right. What about a photograph of a famous 2011 piece of contemporary art taken by the artist? Can you put that in your thesis? Or let's say LibGuide. Let's make it a LibGuide. Can you put that Can you put that on a LibGuide? Okay, so here's where I would say you do your analysis, right? So could you make an argument that it's transformative depending on what you're doing? Let's say your whole LibGuide is for a book on contemporary art that sorry, not a book, is for a class on contemporary art, because sometimes we make LibGuides for specific classes, for specific professors. And let's say the professor or you have a lot of content that you're like embedding near these photos. Like you're not just putting them on for ornamentary purposes or decorative purposes, you're actually like analyzing them. Then you might be able to make a transformative argument, right? That you're like bookending the photograph with like commentary about it. And what about the fact that if you make it smaller, like a thumbnail images are clearly an example of fair use. Google indexes the entire internet daily and uses thumbnail images, and they're not getting permission. And the courts have said that that's fair use. I would also say this is for educational purposes. Is someone going to go to your LibGuide and print it out instead of buying that photograph, that contemporary art thing? Definitely, if it has a CC license, you definitely could. Of course, if you made the art, you could do it. But I also think you might have a transformative argument here. So it depends on what the purpose is. Are you doing it merely for decorative purposes? It's probably not transformative. But are you doing it for analysis and you're like talking about each work of art? Maybe, right? Because I use that argument a lot in PowerPoint. So a lot of photographs and things are used in PowerPoints. And of course, during face-to-face teaching, we have the face-to-face teaching exception, and we can show those. But what if you email your PowerPoint to your students? Or what if you put it on your course webpage? You're no longer face-to-face teaching. There is an online act called the TEACH Act, which allows for showing things in online teaching, but it's really, really poorly written, and very few people rely on it. Most people rely on fair use. And could you make an argument that anything used in your PowerPoint is bookended with materials, right? You're actually talking about those things. Like, for example, right here, did I get permission to use these images in my PowerPoint? I did not. I did not, and I did not cite them. Is it a fair use? What do you guys think? Yes or no? Can I use this? Yeah, I mean, I'm clearly using it to show you what these things looked like. And this is like the actual copy of the book, right? And then there's like a poster to show you like this is what I'm talking about. So that's a transformative use. And no one's gonna print out my PowerPoint instead of like buying that book or it's like really not hurting them at all, right? In fact, I'm advertising the book. I have the book on my desk right now that I bought with my own money. It's like $24. I like the book. I use it for teaching purposes. All right, so guys, don't be so stingy. Don't be so stingy with your transformative fair use analysis. Maybe 2 is a maybe at least. You said, what if your PowerPoint was about the dead? Would it still be transformative? Maybe, yeah, because I'm again talking about historically. Maybe I'm talking about them in historical context, or I'm talking about their music in a music class, right? Yeah, sure. Let's get back to number 3. A graph depicting the temperature each year in Atlanta, Georgia to demonstrate climate change, published in a science journal and authored by a famous professor. Can I use that in my LibGuide? All right. So I like these I love these answers actually because you're showing me the range of analysis. Because someone says yes, it's factual, right? We know you can't protect facts. Someone says you can use the data but not the graphical representation of it. And someone says it's for educational purposes, it's not but not if it's the heart of the work, right? Oh my gosh, these are all really great analyses. So there's a colleague of mine who says that there's this thing called in copyright law called the merger doctrine. And if there's only one way to demonstrate a particular idea, then it merges with the idea and it's not protected by copyright at all. That's called merger. So if there's only one way to show it, now I would say if there's only one way to show it, then you're right, it's factual and it's an idea and you can't copyright it, so you can use it. Now, if there's more than one way to show the temperature, right? Like you could graph it, you could chart it, you could do, or there's anything mildly creative about the way they did it, like word art, you know, an interesting, pretty graph that's in the shape of a flower or something, who knows? Definitely not. You would definitely, there'd be some creativity there. There might be creativity in the arrangement of the data and what years they looked at. If they looked at very specific years for a very specific reason. So some folks say the best course of action, there are a couple things you can do. One, you can use the facts and not the chart, right? So you could certainly use the facts. And you could create your own chart because then you're not copying that chart. Two, you could ask for permission and you'd probably have to ask from the journal publisher, not the professor. The professor probably transferred his copyright to the journal. Or three, you could make the argument that there's a merger if there's like only really one way to show it and use it and cite it. Those, you know, again, like copyright's not as cut and dry as you think. So unfortunately, there's not always just one right answer, but you know, there are multiple ways to get it done, right? So you could, you know, recreate the graph. You could ask for permission. You could say, I don't think it's even protected. But again, all of these things you have to like be comfortable. A lot of things in copyright involve risk, and you have to be comfortable with whatever assertion you're making. So like when I assert fair use a lot, and I'm not a very risk averse person. Now, I'm not going to go jump out of a plane anytime soon, but I'm not really afraid of being sued. And also, like I said, we as librarians making our LibGuides and things and our educational things are pretty well insulated from lawsuits, which is great. So I'm not super worried about it. Also, I come from a law background, so I understand a little bit about this process and everything. But so I think, you know, some of this depends on your risk assessment and your risk aversion. The least risky thing would be to ask permission from the publisher. The next least risky thing would be to create your own graph. The next least risky thing would be to just not even use a graph, just use the data. I mean, that would be actually probably the least risky thing. And then, you know, if you just copy it and use it, then you're taking a little bit of a risk, and you just, you know, would make a fair use assessment and keep it on file. All right. What about an entire copy of a short article published in the 2016 in the Atlantic? Can you just like append that to your LibGuide? Just be like, here, read this. This is really great. Yeah, you guys are like, no, you're right. You probably cannot. Because your LibGuide is presumably available on the web. So that's like really open. So your risk there is really high. But what about like putting that on like a e-reserve? So I got some of those e-reserve questions. Yeah, like links are way better in e-reserve. So, okay, libraries pay licensing for a lot of stuff, right? Our library in particular has a lot of stuff that professors want to use in their classes. So I always tell them, like, the best case scenario is not making copies, right? Because that's what copyright is all about, is protecting copies. So if you just want to link to the library where it is, where the students would have to like log in, then if they start downloading and copying and sending it to their friends, that's on them, right? There's a copyright notice on it. Not to mention the fact that the library then gets the statistics for how many times it's accessed. So for instance, instead of you accessing it once and then uploading it to your web page, now it's being accessed 500 times. So we know that that journal article is really important. We're not going to get rid of that journal anytime soon, right? So there are many reasons it's better to do that, just link, so the students have to log in and get to it. And then the students, of course, could download a copy. They're allowed to under our licensing. If it's a book, right, we do the fair use analysis, which is the classic, four-part test. If we're just making pure copies, it's not transformative. And when I mean pure copies, that would be like e-reserves. I mean, e-reserves are not transformative, right? I mean, we're not making PowerPoint, we're not making a presentation, we're not making art, we're just like literally making copies. And that's where you do a straight four-part test, and there's no set rule. So someone in one of their questions said, what about like 10% of the work? Isn't that the guideline? Well, unfortunately, that a lot of people use that as a rule of thumb, and I really get frustrated by that because that was actually promoted in the Circular 21 guidelines by this US Copyright Office, and it's not the law. Okay, that came from the legislative history, and it was meant to be the low bar, not the high bar. So 10% was meant to be the minimum amount, and even less than 10% could be a violation if it's a quote-unquote heart of the work. So the long and the short of it is the copyright and fair use is meant to be a case-by-case analysis. It's meant to be done on a single work. There's no set amount. I mean, obviously copying an entire work is not okay, but beyond that, you need to do a case-by-case assessment. And a really good place to look would be Kenneth Cruz's fair use checklist. That's a really, really good checklist on the Columbia website. There's an ALA fair use evaluator tool. Which is also a really good one. And Minnesota, the University of Minnesota has a fair use tool as well. So any of these things would be good. And when I meet with faculty members, about their e-reserves, I point them to these tools and I say, I can't make the fair use analysis for you. You're going to have to make that determination, but then keep that fair use assessment on file. And you cannot make a global fair use assessment. So you can't say, well, everything's for this class, so it's all educational, so I'm done. You have to look at every single thing. If you have 40 readings, you have to go through 40 readings. And of course, we're only talking about the stuff that is not licensed by the library. The stuff that's licensed by the library, of course, your students can use because we paid for it. It's just better to link to the library than to, download and then upload it. All right. Yeah, there's the fair use evaluator tool from ALA. Yeah. The last practice question is, photograph taken by a famous professor that you scanned into the computer and made into a Picasso-like cubist rendition with new colors and text. That's meant to be my transformative example. So, like, can you do that? Yeah, you can do it. Yep. All right. So I have library guides. I have many library guides. This is my most used one, the Copyright Reference Guide. You are obviously welcome to use that. Yeah, there's the Minnesota Fair Use Assessment thing. You can always email me. It's srbenson@illinois.edu. I love talking about copyright. I'm somewhat of a copyright geek. I find it really fun. The more challenging the question, the better. And so, feel free to know that I'm here as a resource. And I'm always happy to answer questions. And speaking of answering questions, if anyone has a burning question that I didn't get to, I tried to answer the questions I got beforehand, but I might have missed something. Feel free to post it into chat, and I will address it. All right, I have a question about fair use and using material in an online course. Faculty member would like to use a PDF of a single chapter of a book. That title isn't covered by copyright clearance and or license. Can we consider using that chapter in an online class as fair use? If so, can it only remain there for a limited time or for as long as the class is used? Oh, I love that question. Ariel, thank you for asking that question. So first of all, like the 10% rule is like just not really a rule. So, but yeah, I mean, if it's less than 10%, that's a good thing. It's not covered by Copyright Clearance Center. Okay, I'm going to go a step further, everybody, and be like a militant radical librarian and say, I don't care if it's copyright by CCC or whatever. The Copyright Clearance Center can have licensing, but you know what? If I'm using 2 pages from a book, even if they're willing to license it to me, it's still a fair use. Just because they're willing to sell me that doesn't mean I need to pay for it, right? So, I mean, yes, the fact that it's not under the Copyright Clearance Center is helpful, but even if it was, I would say like, that's okay. And yeah, you can put it in the online course. It's really helpful from a risk management thing if it's behind a paywall, like, so like if it's in like a course management system and not just on the open web, right? So that only the students can see it, because also you're making it less like accessible to people. And can they only use it for that one time? Now, that's more of the Circular 21 guidelines things that hang on, unfortunately, where they said it had to be like spontaneous and it had to be, you couldn't use it over time. Okay, that's stuff that the U.S. Copyright Office makes me mad about, because that came from legislative history. Courts haven't looked at that. I don't think that matters. So can you keep using that chapter? Let's say I'm going to use that chapter for like 10 years. Yeah, you're using one chapter. If it's not the heart of the work and you've determined it's copyright fair use, yeah, you can keep using it. You don't have to keep like changing your readings every year because you feel like, oh, I'm going to get sued. No, no, no. And that's a holdover from Circular 21, which I hate. I have a whole article on it in the Journal of Academic Librarianship. You're welcome to read. But I hate Circular 21. I really do. I wish they would revise them, and they won't. I don't know why. Okay, follow-up e-reserve question. Oh, what? Okay, hang on. You said, Emily Gilbert, do you have any general tips for for-profit institutions? We don't have a lot of these superpowers because even our courses are considered commercial. Okay, so for-profit, you can still assert fair use, right? I mean, Google does it all the time. You can read some of the cases. I mean, Google is clearly for profit, and they're allowed to index the entire web with thumbnails and things. So I don't want you to feel like, oh, we can't do any of this stuff. All right, you just have to make a fair use assessment. And the example that I used of the Grateful Dead book, that also was commercial. So, and also I would say the more transformative the use, the less the courts are kind of worried about the commercial nature, right? Now it gets trickier in e-reserves and stuff for sure, because that's a pure 4-factor analysis. But in the transformative realm, I think you should feel a lot more confident asserting fair use, even in the commercial context. Follow-up e-reserve question. If you use a section of a chapter once under fair use, can you claim fair use next year? Yeah, I think I already answered that. I get, yeah, this spontaneous thing, it's so weird. When you're a teacher, you're not that spontaneous. I mean, you use materials multiple years, right? And that's okay. All right, Linda, what about newspapers, magazines, and yearbooks? Some claim they're in public domain, some say not. Some say the articles and photos are not. Oh gosh, oof, duh. All right, so Linda, I actually kind of love this question because I'll have more information for you soon. I'm actually going next week to an entire workshop about digitizing newspapers, and it's about copyright issues. So like, stay tuned, and if you want to catch up with me after that, I can give you more information, but I haven't done the workshop yet. So, but I think the answer is like a lot of the stuff in the newspaper is work made for hire, right? So it would be, and most of the content in a newspaper is work made for hire, right? It's people who work for the newspaper who put out content. So you would probably follow the work made for hire timelines, which I think are 95 years from date of publication or 120 years from date of creation, whichever is longer. I think I'm saying this right. And that's the rule of thumb. Now, that doesn't mean you can't still assert fair use. You can still preserve them. So I think a lot of what we're doing in this workshop is to say, like, let's not be too scared of preserving newspapers, especially printed newspapers when there's limited copies. If we're doing copies for preservation, we know that's okay, right? It's going to like deteriorate. Digital content's a little different, right? Because digital content isn't going to deteriorate anytime soon. There are other, fair use still applies, and I guess what I read from the materials that I got was basically like we're not too worried about the risk here because it's also like historical stuff, so fair use is pretty strong there because we're trying to preserve history in the newspaper, as long as it's not like just like a fun guide, right? You know how some newspapers are more like advertising fun things or whatever around town. It's not that kind of newspaper, but if it's like hardcore like news reporting, then fair use arguments are pretty strong for the factual nature of them or historical nature. Okay, what am I missing? I had a magazine from the 70s and the publisher was defunct. Some are saying they don't have copyright notice and therefore are public domain. Yeah, Linda, look at the copyright digital slider. I think in that era, you're right. I think if there's no copyright notice on it, then it would automatically fall in the public domain. And also, I'll tell you this, a lot of librarians feel pretty confident asserting fair use when there are orphan works. And orphan works are when publishers are defunct and we cannot figure out who owns the copyright. And what we usually do to cover ourselves in that situation is we put a takedown notice indication on the website. So if I digitize something, put it on a website, I'll say like, if you are the copyright owner of this material and, wish to contact us and would like that taken down, please contact, so-and-so person or whatever. And that kind of covers you a bit because then if they want it taken down, they're supposed to like contact you first, not sue you, right? They're supposed to contact you and ask you to take it down. So with orphan work, that happens a lot. Linda, you said, does this apply to school yearbooks too? So that gets into the question of if it's considered published or unpublished. And published isn't like what we think of with published, like produced. Like published is about a legal definition, and the legal definition changes over time. So I'd have to think about that one because we are with the copyright notice thing. We're talking about published works, not unpublished works. And unpublished works are usually protected even longer under copyright. So I'd have to think about that one and look at the legal definition of publication at that time. And if it were considered published, then yes, from that era, the answer would be yes. But if not considered published, then the answer would be different.
Right,
Sorry
and
for weird.
we do have a few more minutes. If anyone has any questions, or Sarah, I'll ask you, since we had questions that were submitted to you, did you find any of them particularly interesting that you might want to share the question and the response with the entire group?
I can't necessarily answer it on top of my head. Any other questions? I think I answered all the other ones I saw. We've got about 5 or 6 more minutes. Well, I did share a lot of them as I went through. Oh, okay. Well, one of the questions was, can faculty show a home video in a classroom? And my response to that is yes. Face-to-face teaching. If it's their home video and it's like, yeah, sure, they can show whatever they want if it's a legal copy and it's face-to-face teaching. What are the best websites to have faculty and students use for copyright laws and rules? I really would recommend the United States Copyright Office. They have the circulars there, and the circulars are really good. The only one I really hate is Circular 21, but the rest of them I really like. So I would say with caution of Circular 21, but I mean, Circular 1 of the Copyright Basics is really, really good and really straightforward. And a lot of those circulars are very straightforward and meant to be open to a general audience. And so I would recommend that. Okay, so someone wrote, if a university has photographs from past events and the library and archive can't find the photographer or the photographer is deceased, how would you go about determining copyright? Do the photographs belong to the university? Oh, goodness. So I wrote, it depends. Because it really depends on if those photographs from past events were work made for hire thing. So a lot of times, so if the university hires a photographer for an event, they'll have an agreement with the photographer where they say, like, we're going to own these photographs, right? Like, you don't want, like, I had my headshots done, and I own them. Like, the university paid that person, and they want them. They don't want the person to be like, no, you can't copy these or put it on your website or whatever. So it depends on like what the arrangement was, but I think most of the time you could like assume, and that the university probably owns those if they're from events thrown by the university. The problem is, and it gets trickier if they were submitted by like individual people who attended the event, then they're not like works made for hire, right? Like they're just like, oh, my Aunt Marge came and she sent in these photos, and then you don't have any like agreement from Aunt Marge. It gets trickier. But I mean, if we hired the photographer and they were official photographer to the event, then probably the university owns those. And someone wrote, can an institution get in trouble for having inappropriate rights statements? My response to that is doubtful. I mean, but I do think it's a good idea to try your best to make them as accurate as possible because people rely on those, like people who are accessing, the archives online or they're accessing your online digital collections. A lot of folks don't understand copyright. As you've noted from today's presentation, it gets complicated very fast. And so, if you don't really know the copyright status, it's way better to say we don't know than to say copyright University of Illinois Library or whatever, because then, you're being if you're letting the person know we don't really know, then at least they can dig it up themselves and think hard about it. But if you're saying we own it, but you really don't, that's actually kind of worse because you're locking it down where it might be public domain. So I actually really encourage people to try to engage with the DPLA rights statement as much as they can and come up with a workflow. I actually have a really, really great article or book chapter coming out all about how to kind of go through those copyright processes for DPLA rights statements and to use them in your library. And it is not published yet, but when it is, I can let folks know, and you guys can share it, share the information. I'm thinking it's going to be helpful. I wrote it so it could be helpful. I hope it is.
Well, and we thank you very much for
Emily,
sticking with
so
us
sweet.
for
I'm actually teaching
2 whole hours and
course
talking all about
in
interesting copyright stuff. We really do
online.
appreciate
so
it.
if anyone knows anyone who's in the
I think that now that we have come to
classes,
the end of our time, we're going to give
a copyright
Sarah
class
a break,
and co-teaching it this summer
so
online,
she can get a drink of water. And we will be exiting this room in just a minute. So thank you all very much for participating.
I really enjoyed
in this
coming
session.
today. You guys are a great group. And again,
so much
please
to
feel
Sarah
free to email me when you have
this for us.
questions.
We do appreciate it.
Really love helping out librarians, and my job is a lot of outreach. So